This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I am Noah Ballmer, your host, and today I'm very excited to speak with Professor/Dr. Timothy Fort. Professor Fort is the Evely Professor of Business Ethics at the Kelley School of Business at Indiana University. At Kelley, he coordinates the undergraduate ethics program, where he's the recipient of the Distinguished Career Faculty Award. He's taught business law and business ethics for nearly 4 decades and is an esteemed author with a number of published books and articles. And he holds both a JD and a PhD in theology and business. Professor Fort, I appreciate you joining me here today at Discussions at the Roundtable.
Thanks very much for having me. Look forward to it.
Absolutely. So let's get into it. You've made a career of teaching and writing on a wide range of topics, but chiefly on the various intersections of ethics, public policy, and social issues. So why don't you tell me a little bit about your background and how ethics became a primary area of inquiry for you?
Oh, sure. It actually started when I was in law school. I was at Northwestern Law School and I was going through my first year, and I was actually rather disillusioned that we were being equipped with all of these incredible advocacy skills, but I didn't think we'd paid enough attention to ethics. And actually, I got lined up with an associate dean who said, well, the law is value neutral, which I thought then and I thought now was ridiculous. And so I knew where I was going to go back to practice. I was going to go to my little hometown of 800 people and practice law with my father. And so I didn't have to spend summers with summer internships and stuff like that. So I decided I'd get a master's degree essentially in ethics during summer programs back up my undergrad alma mater, which was Notre Dame. And that just led to an ongoing interest of ethics throughout my career. And I got a break after teaching business law that Loyola University said their priest had decided to take the summers off. Do you think I could put together a business ethics class? And I did, and I loved it. And I just kept going from there.
Oh, wow. That's a really interesting story. So it's kind of been almost since the very beginning, that's really been your primary focus.
No, it has. I mean, it has always been a focus of mine, and just continued on throughout the entirety of my career. And it just seemed that once I expressed an interest in that or started to look at interest in that, unexpected avenues opened for me. And so it was a perfect thing for me to pursue. And I would say one other thing in terms of your introduction on coordinating the Kelley Ethics Program, we have the largest ethics faculty in the world. We have 22 full-time ethics faculty, and I'm sure that that's the biggest in the world. And so it's really remarkable looking back. I wish I could say that I had some great strategy that I had designed years ago, but frankly, it was dumb luck and some good opportunities.
Sure, absolutely. It's unfortunate that more universities don't have such robust ethics programs because it's such an important area. And I agree with you. I'm a former attorney. I went to law at Case Western in Cleveland and had a similar experience where a lot of my professors were, ethics. It was a very neutral topic, and it's something that I wish people were delving into more, that intersection. So yeah, no, it's certainly impressive that you've managed to build an entire career out of this, and it's certainly an important area. How did you parlay this into expert work?
Sheer dumb luck. That's the story of my career.
That's the through line here.
So, I was asked to do ethics testimony work for a long, long time, actually, and I just turned them all down. It was at the time that I was going through my promotions from assistant to associate to full and all of that kind of thing. And it really, I felt that I needed to be focused on what I was focusing on in my academic career. But then it was about 8-9 years ago that I got one that just struck me as this would be a really interesting one to do. This one is one that I can talk about. It was to do an assessment of the Ethics in Government Act as applied to an individual that was part of what was then, and I think still is, the largest tort case in American legal history, a $5.7 billion court case. And I looked at that, and I was also looking at the fact that my kids were getting close to getting ready to go to college. And
Sure.
I said, "Now, this is a pretty interesting case, and it's a big case, and so let's try it out." And I knew the law firm had high respect for the law firm in Chicago. And so I thought, let's give this a try. And it was a fantastic experience.
Even so, in your very first go around as an expert, it was a fantastic experience. I don't always hear that. So, what was it like the first time? How they just reached out to you, or
They did. There was someone in their office who had had me in class or heard of me from someone who had me in class or something like that, and they reached out to me. They needed a rebuttal witness, and they called me up, and we headed off right away. And they were I mean, those attorneys. It was Winston and Strawn in Chicago. They were absolutely fantastic. They had two lawyers assigned to me, and again, this was a huge case, and so they really spent the time to coach me, to train me, to do mock interrogations. And I mean, they couldn't have provided a better orientation for how to do this. And I was deposed and never got the case was settled at trial anyway. And so I didn't, testify at trial, but I certainly went through a rigorous deposition. But they were just there for me. I mean, I always felt that they had trained me well. They were there to protect me. They were they're cheering for me. I mean, it was a feeling that they were all in for Tim. It wasn't just that they were doing something advocacy for their client, which of course they were doing, but
right?
they were personally supportive of me as well. And so it was a high stakes case. It was a big time firm from DC that was on the other side. So I mean, it was throwing into the deep end right away, but it really worked out very well.
Let's talk a little bit about that preparation that helped you so much. What specifically helped you as an expert? What specific preparation methods or coaching, or you said mock depositions? What let's get a little bit more into that. What specifically were those things that you would say attorneys should be doing to help their experts that they're bringing on?
Well, one thing I would say from the get-go is that I, a potential expert witness, really want to hear the words from the lawyers that we want your independent opinion. There's a way that we would like for this to go. We would like you to be supportive of our case, but if you don't think that we have a good case, we'd rather know now rather than later. I think that's really important for an expert witness, so that you don't get into so that you can authentically be able to speak of what you believe, and you don't get yourself into a trap of, that's not what we want you to say, that this is what you want to say. And so
Right.
that is really important to me, as is another one, that a promise of whatever you believe that you need in order to render that opinion, in terms of the number of depositions, or if you need to interview somebody or whatever, that you let us know. And so those are two critical things. Those have happened in all of my cases, actually. But that, of course, creates an avalanche of work for you to go through. And so, but with those two things, then, in my case, I mean, I'm not like a scientific medical expert or something like that. And so I don't know, but I'm guessing that they probably don't read as many things as I do. But a law and ethics person is reading. They may be
Sure.
doing more scientific analysis or a test or something like that, but I am reading. And so I may be reading 1,000, maybe even 2,000 pages for a case. And so I need to, do check-ins with the lawyers as I'm going on. This is kind of where I am right now. And sometimes they can help me fill in the blanks. Sometimes I can push them on questions that I'm not understanding. But having kind of regular check-ins is really helpful to make sure that I'm not off on the wrong track, or I'm misinterpreting something. And then I really want, and this is a kind of a third thing that I want when I'm, being interviewed. I want to promise that they are going to grill the heck out of me before we go into the deposition. I mean, I want it. I referred to that first deposition when we were doing that. We did it for 2 days, of the evil counselor, and then I'll fill in the blank of the counselor's name, because she was just really ripping me to shreds, and it was exactly what I needed. Because she made me much more focused, and even if I knew the answer that I wanted to give, there's a stylized way that you give it. I mean, it's not just a conversation, and so getting used to how to speak was important. So those things, I mean, assuring the person that they want an independent opinion, giving you everything you want, helping them with, occasional check-ins, and then really providing, not in a nasty way, but a really rigorous way. That's really helpful for me to have an attorney engage with me.
How difficult is that when you're sitting there being grilled, how do you deal with that kind of stress and pressure? Is it just because you've been well prepared for it, or do you have some other strategies or tactics to kind of bring it down and make sure that everybody's keeping their cool and keep things objective?
The hardest one is the prep, as it should be. And I'm an old athlete. I mean, I participated in athletics when I was a kid, and our coaches always said that the practice ought to be harder than the game, and I really believe that. And so, and in the practice, I'm in part because I'm really wanting to do well for attorneys that I've developed a relationship with. But once you get into the game, I think it's important to keep in mind that it is a bit of a game. I mean,
Hmm.
it's a stylized kind of a fight, is what it is. It's rarely personal about you. Even when they people are pressing on you, it's something that they have to do, and that that they're doing, that is not necessarily tearing you down as a human being, but really pressing on you and your views. Now, as an academic, I get some training with that all the time, because that's what happens when you present a conference paper or whatever, that people are picking at you. And so, in some ways, that it's like that. But if you can keep it that way, then the stress level goes down, I think, a lot. Another thing that helps, it helps and hurts. There's an old adage that a person's biggest strength is also probably their weakness too, and that's true of me. I mean, I remember in my first deposition that my attorneys counseled me, said, "Now be careful of these guys, the other side, because they're going to be very friendly before they go in, and they're going to chat you up, and but then they're going to go in hard, and so you got to remember that you're still in the midst of this fight. It's not just a friendly conversation." And I just laughed at him and said, "Oh, I play that game really well, because again, I played a lot of sports, and particularly baseball was my favorite, and I stole a lot of bases. And I was a pro when I got on first base of just chatting up the first baseman and him with me on all kinds of things. The party last week that maybe we went to, or the pretty girl in the stands or whatever. But I knew when I was making my break to steal second base too, and so I said, I can handle that. I can handle that really well. But again, that makes it a little bit of a game. You know what you're there for, you know what you're
Right.
supposed to do, but you're diffusing a little bit of the tension on that. In this last deposition that I did, I can't reveal details of it just yet, but there was one point where I truly admired both parties. I liked both of the companies. I thought that the party that I was speaking on behalf of was correct, and that the other side was wrong in the particular thing they were doing. But I liked the work that they did. And the opposing counsel said, do you have any personal relationships or views on the company? And I said, well, I like both companies. He said, "Well, do you like your company?" I said, "I just said I like both companies." He said, "I know." He said, "I know, but I have to ask the question." I recognize that, and he has to ask that question, even though he knows what the answer is. He has to make the record to ask the question: is there a personal bias that you have? Now, the weakness that has, I just said that was my strength, because it helps me diffuse the situations, and kind of have a bifurcated way of getting into that. The weakness is that, as you probably can tell already, I'm a pretty affable guy, and my counsel have frequently warned me, said, "Tim, this is not a conversation. I mean, this
Hmm.
is this is a fight, and so answer the question, just answer the question. You don't have to go beyond the question. You answer the question. And I know that you want to be affable, but don't jump into your answer. Wait a second, collect your thoughts, and then know what the words are that answer the question, rather than to jump into it and then spin off in a bunch of other tangents, because you're this friendly professor who likes to talk a lot." I have to be reminded of that. But that affability and that recognizing that you're in a game kind of a situation also reduces the stress a lot. So it's a little bit of both.
Oh, so I mean, you might say, I guess, that it's a little bit more like chess than boxing to some degree, because
I I play chess. I haven't boxed, so I don't know. It sounds like it sounds like a good analogy to me. Although every once in a while I do see boxers that afterward they give each other a hug or something like that. So I mean
sure.
I mean other than messing around when I was like 9 years old and the backyard with some friends, I haven't done any boxing, so I don't know that for sure. But it probably is a pretty good analogy.
Do you find that there's ethical considerations when it comes to being an expert? Because you were talking about how you like both companies, but you're clearly being employed by one and not the other. So what are the ethical considerations in performing as a witness and telling the truth? And as you said, at the outset, making it clear that you're going to be honest about your expert opinion on things. What are the ethical considerations that are kind of pertinent to that?
Yeah, that's great. That's a wonderful question. And that is exactly why at that first meeting, I want to hear the assurances that they want to have my independent view. And because then I can speak authentically and truthfully to what I believe, as opposed to being an advocate for a position that I am paid to advocate for, but I may not necessarily agree. I struggled with that when I practiced law. There were a couple of occasions where I thought that my client was just a, a degenerate, and it was very, very hard for me to be representing them in the courtroom. As an expert, I want to make sure that I can speak truthfully to what I believe, and I have with my counsel said, I can say these things. These things are all true. I think this is weak for you at this point. And that kind of got a bracket off the table, or they were aware of that and they appreciated that. So I think that that's the biggest ethical thing, is to be able for you to be able to say honestly what you believe. Now, of course, you can frame things in the words that are perhaps more helpful to your side than the other, but without going to the point where you're not misrepresenting what you authentically believe. And at least for me, that is a really, really important thing.
One of the other things that I found very interesting while reading your bio was this concept of cultural artifacts. It seems to be, a new area of inquiry, I guess, into the way that we can kind of relate to one another in more hostile situations. Because I think that that has applicability to what our conversation is about, to being an expert, or to dealing with hostile counsel, or whatever the situation is. So tell me a little bit about your cultural artifacts approach to solving the differences between people.
That's a really dangerous question because you can get me talking about this one for about 5 years. I mean, this is this is the heart of where I am right
Hey, I
now.
have as much time as you do, so
So, well, let me back up for just a second.
sure.
My brand, if you will, has always been, I kind of get credit for inventing a sub-academic field of how ethical business behavior reduces the amount of violence in the world. Because what we talk about of ethical business culture maps very well what the anthropologists say are attributes of relatively nonviolent societies. And so I started to write about that in about 1999. There's now a huge subfield that has developed as a result. And I and a couple other people were the only people that were writing. In fact, many friends were saying, "Please don't do this because you're committing political suicide or career suicide on doing this, because it's just so weird what you're talking about." And but I've written 4 books on that topic. 2 have won Best Book awards. I mean, that's what my brand is. But then I came out here to Indiana University. I was previously at George Washington University, right in the milieu of Foggy Bottom and the White House and the State Department and the U.S. Institute of Peace. I mean, what I was doing was fitting really well. And one of the
Sure.
great things about Indiana University is it has arguably the world's best school of music. And I do have a music background, and my kids were taking music piano lessons when they were 6 and 9 years old. And it just struck me as I was waiting outside of their room, why couldn't you use music as a way to nudge people toward thinking of things in a certain way as opposed to other ways? Because music gets into our bones. I mean, we don't just listen to music. We tap our hands and tap our feet, and we bounce our head and we sway and we dance, all those kind of things. And that turned me on to this notion of could we use what I call cultural artifacts, music, sports, stories, films, suppers, our pets, to be one to nudge us into thinking once we're having the experience with something, to nudge us into looking at things a certain way. We look at things in a friendly way as opposed to a combative way. You mentioned boxing earlier. If I want to think, I do this as an exercise for my students. If I want to put myself into a combative state of mind, I'll listen to the theme from Rocky. But if I want to put myself in a state of mind where it's golden rule and being reaching out to others and being friendly, I'll listen to the theme from Friends. I mean, listening to the music puts you in a kind of a different state of mind, and so those are the nudges, and then they also become bridges because we can find common ground even with if we disagree with each other politically, socially, or in a deposition with others that give us a common ground beyond that thing in which we are conflicting. So, a common story about a sporting event or a favorite music or a favorite movie or telling stories about our pets. There's an organization called Braver Angels in this country that gets conservatives, conservatives, liberals, Republicans, Democrats to sit down and talk with each other. How do you start that conversation? I mean, that's a tough conversation to start. And one of the things that Elizabeth Bernstein, who's a reporter for the Wall Street Journal and an IU grad, told me in an interview is that the thing that they often start off talking about is their pets. It's kind of like, how's the weather? It's an icebreaker. It's so translate all of that. So I'm writing like crazy on that. I've got 2 books going on that one, maybe a third. Got a lot of stuff going on that. But to translate that into a deposition, in this last deposition, I did a little bit of homework in advance, and I saw that what the opposing attorney that was going to be deposing me was from the University of Michigan, which is where I spent first 11 years of my tenure track career. And so, I introduced myself right away when we came in, shook hands, and said, "You're a Michigan man." And then it very quickly came out that both of our sons play baseball. So we were telling baseball stories. So that goes to what I was talking about earlier, that it was, finding a way to connect with somebody, but you're still in a competition. But I do think that those kinds of small little things do diffuse the atmosphere a little bit. I don't want to go too far. I mean, again, people are there for a reason. People are
Right.
there because the legal system is an alternative to violence. I mean, that's
Right.
why we praise it. It is. I mean, it's how do you settle disputes if you don't have a legal system or some sort of a arbitration or system? I mean, you resort it by fighting. And so I mean, it is still that, but I do think that it can create an atmosphere that is a little bit more professional and not quite maybe as harsh as it might otherwise be. So I do think the cultural artifacts can have a role in a expert witness situation.
How do you walk that line, between wanting to have those connections and be affable and remembering that it is ultimately a combative situation? I know we talked about a little bit before, but ultimately, what is that line? Is it fuzzy or is it a hard line?
It's a wobbly one, fuzzy wobbly, that's for sure. It is because and for the reasons I kind of indicated earlier that
Right.
I mean, I don't have a difficulty at all, just like when I was stealing second base. I don't have a difficulty at all that, once the questioning starts, I'm not going to break in and talk about baseball or something like that. I mean, that's not difficult to separate. What's
Sure.
difficult to separate is once you are chatting or once you are being interrogated and you have been chatting to
Hmm.
then hear the question and move into conversational mode as opposed to interrogation mode. And I do struggle with that. And that's the one criticism that my counsel has given me during breaks is, Tim, slow down. I want you to take a deep breath before you answer the question because you're being too friendly right now. It's not a conversation. They said it's not bad, but you said most of what you're doing is terrific right now, but you'll be a little bit better if you just take that deep breath and then stay within the lines that you've established. Because I do stay within the lines, but you can seep into my mind. Maybe not everybody's mind. My mind is that I can fall back into the kind of a friendly chat that I had with the guy when I was outside of the actual I'm under oath.
Right. Right. So it looks like you've had a couple expert witness. So far, you've been an expert witness a couple of times. Is that right, or has it been more than that handful that I see?
It's been three times right now
Okay,
deposed because one I can't disclose yet, so it's not on my
sure.
profile or anything like that. So I've been deposed three times. Excuse me, I'm currently under retainer for a fourth one. I've served as an expert witness as a just as a written kind of a document or a written kind of opinion on three other occasions or three other instances. But those were separate from, you know, kind of an internal memo to attorneys as opposed to something that you're going to have to testify on behalf of.
Wow, what are those documents like? How do you prepare for that?
Well, those are fun. Those are almost like an academic exercise. In fact, one of them, what two of them were for the same set of attorneys that I did the first deposition for. They wanted an internal memo and something else, and one of them
Okay.
ended up turning into a law review article. It
Oh,
was it was a question that we, with their permission, it was a question that came up in the case that wasn't directly related to my case, but we all agreed was an interesting question. And if I were up on a stand, it was more of a business law ethics as opposed to the particular thing I was testifying on. And they said it would probably be good for you to really have a good foundation in case you were interrogated on that of, well, have you thought about the ethical implications of blah, blah, blah. And so I was like, well, we should do an analysis of that to protect me to make sure that I have an answer and I'm not fumbling around if that ever happened. So, I
right.
mean, it's like an internal memo, almost like you know, a third year law associate would do in a big firm, or a draft of an academic article. So, I mean, we would agree on what the assignment was, and then I'd write the draft. There wasn't as much back and forth on that because it wasn't something they were prepping me specifically for. But then I would
Right,
give
of
them a
course.
draft, and they'd give me a response on that, and then I would refine it, and so it was ready to go as kind of a another arrow in our quiver in case we needed to use it. Those were a lot of fun because you have no pressure at all in
Right,
terms
right.
of being, well, you don't have any pressure. I mean, we did it so that it would protect me in case it did come up. But I mean, it was really proactive as opposed to something that you know you're going to get grilled on quickly.
Right, right. Do you find that there's any differences depending on forum? In other words, do you have to know the ethical framework where you are, and then also federally, and then also maybe even internationally? I don't know if you've done any international expert work, anything like that. Have you had any call to have to do significant amounts of research just to find out the governing laws in a particular forum?
Definitely, it's a great question. I have not done international, so I'll put that off the table. But you know, in the second case that I did, it was a fiduciary claim case of a non-compete clause, and you know, could an officer move to another company and, you know, dispute over that? And there were multiple states that were kind of involved, the key state of business, the state of incorporation, and stuff like that. So, and states really differ, particularly on that issue of fiduciary duty
Right,
and covenants not to compete. uh,
sure.
and so, I mean, I had to do quite a bit of state to state research in order to know exactly, you know, what laws is applicable that we're talking about here. The other thing, though, that is related to your question that I think has been an interesting thing for me, again, as a law slash ethicist, in the first case, the opinion that I was asked for was very specifically the legal interpretation of the Ethics in Government Act. I mean, that's a specific law pertaining to governmental employees. And so I
Right,
had that legal analysis, but then I also added on some more pure ethics analysis to it. And basically, the legal part was relevant, and they really didn't care about the other part. On the other hand, in the other case, the fiduciary duty case, that was a federal case, and the judge said, "I'm the one who decides what the law is. Thank you very much. An expert isn't going to tell me what it is." But they were
ah,
interested in the ethics part of it, so they didn't want the legal part of it. But they did want the ethics part of it. And so now one of my questions when I go into a case, you're asking, what do you want to know from your lawyer? It's like, what's the jurisdiction? What do they want? Are some things, do they want legal? Do they want ethical? is there a way that we build both of those in, and how do we structure that in order to be able to do that? So that does become a really interesting question, particularly for my kinds of work, of exactly how do you blend those, or to try to get the maximum kind of opinion you can from me without violating any of the jurisdictional preferences that you have in place.
One of the other attorneys that sorry, one of the other experts that I was speaking with mentioned that they recommend having LexisNexis or Westlaw accounts for that reason. Do you keep a Westlaw or a LexisNexis account just to stay, easily be able to search the case law or the relevant documents in any particular forum?
We have that available through our university. And so, I mean, I do use that. And since I do have a record of being able to turn expert witness cases into actual research publications, they're okay with me utilizing it for that purpose, because they see that's an opportunity, even though there's a little bit of kind of a, doing it for, outside of the university. But at the
Right.
same time, it's something that I use in my classes all the time, the experiences, and it's stuff that I write on. So, but yeah, it's really useful to have that, particularly if you're looking at a case. I mean, you can find a lot out on the internet just generally these days, but it's really helpful to have something like that if you're having to figure out what Mississippi says as opposed to what Michigan says, and everything else
Right.
in between.
Do you have any other tips or strategies you'd like to share with other experts or potential experts going forward?
Um, you know, I um, uh, I know that people get stressed at this. I get stressed about this too. I used to get more stressed about it, but that first attorney that had me work, and that was such a wonderful experience. And I got ready for the second one, and I developed a relationship with these people. They became colleagues, and I was asking her. I said, that first one was just so good, but I'm still a little bit stressed of what the next one's going to be like. She says, Tim, so you have a bad one, and that means that you had one good one and you end a bad one. You're batting 500. That's not bad. And so if you have a bad one, remember that you had a good one too. That one ended up being really good too. Again, that's another one of those things of stress release, particularly if you get into it. That most of my experience, at least to date, it might change. That might change, but in those three, I had I had very good attorneys, but I also had respectful questioners. I mean, they did their job. They were tough, they were rigorous, but they weren't jerks either. Now, you can have a jerk. I'm not saying that there aren't out there, but
Right.
it's not as I mean, it's not as personally risky as what you might think it might be.
Wow. With that, Tim, thank you very much. I really appreciate you being on the show, and I look forward to speaking with you again sometime. It was a fascinating conversation.
Great. Thanks for having me. This was fun.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcast or your favorite listening apps.